See, when any court passes an order, it is typically against one party and favors the other party. So the person who is aggrieved by the order thinks of preferring an appeal. But appeals are allowed for the orders which are specifically mentioned under the provisions of Code of Civil Procedure. So where the appeal is not maintainable or the orders are not appealable, the logical route is revision under section 115 of Code of Civil Procedure. Now, the main issue before any revisional court under revisional jurisdiction is that whether the impugn order, that is the order being challenged before the court, is a final order or an interim order. The moment court makes out that the order which is being challenged is an interim order, the moment the revision will be rejected outrightly. But the problem is the distinction between the final order and an interim order is not straightforward in legal practice, and it takes years of time for the court to decide whether an order is an interim order or a final order. So to better understand the distinction, we will follow the Supreme Court ruling V.C. Shukla versus State through C.B.I, in which the Supreme Court given an effect what is an interim order and what is a final order. So if there is a case or a material or substantive issue before the court, and if any order disposes that suit or case or that substantive issue and decides this all material controversies in the case, in that case that order is final. And orders which come up during the pendency of the suit, which does not decide the final rights of the parties, are interim in nature. Although this distinction is a lot disputable, which I will tell you afterwards. So now we will take the example of condonation of delay order, whether it is interim or final in nature. So one of the argument is the condonation of delay order can be interim, can be final, depending upon the nature of the same. For example, a party has preferred an appeal after delay of time, therefore a condonation of delay application has also moved. Now, if that condonation of delay application has been rejected by the court, in that case, the appeal cannot be heard further. It means it has disposed of the appeal, therefore that condonation of delay order can be termed as final. But if that condonation of delay application is allowed, the appeal can be further heard on merits. It has not disposed of the rights of the parties, therefore that order is interim in nature. But there is a rebuttable argument to this also, that although the condonation of delay application, even if allowed, has not decided the appeal or the suit, but has decided a major issue before the court, that whether the appeal can be heard or not. So even if it is decided the issue before the court, therefore the order can be termed final. Now there is another rebuttable argument to this, that before deciding the condonation of delay application, the appeal cannot be heard. Before hearing, the issues are not formed before the court. So this condonation, the limitation time bar is not an effective issue before the court. It is just an application deciding the procedural hurdle and not any substantive issue in the case. So with that logic, if we see, again this condonation of delay order is interim in nature. So see, there is lot of this confusion right now. So for better clarity, we will take the help of Supreme Court ruling State of Jharkhand versus Ashok Kumar Chokhani, which is reiterated in Pathapati Subba Reddy versus Special Deputy Collector, which said that the merits of the case are not decided while deciding the application for condonation of delay. So it is giving an inference that the merits of the case are not looked upon. Therefore, the condonation of delay application is entirely procedural in nature and for deciding the procedural hurdles and not the substantive issue, because no merit has been seen. Therefore, the order should be interim. But again, there is a rebuttable argument to this, that another Supreme Court ruling, collector land acquisition versus Katiji, which is a very famous Supreme Court ruling, which has laid down various essential elements of condonation of delay. And it has laid down that a meritorious case should not be thrown out just on the technicalities of limitation time barred. It means that while deciding condonation of delay application, the court is not only looking on the limitation law, procedural law, no. It is saying the meritorious case should not be thrown out. So whether a case is meritorious or not is to be ascertained by the merits of the case. So while deciding the condonation of delay application, court is also looking on the merits of the case. It means that this condonation of delay application is not procedural in nature, rather it has the essence of substantive law. Therefore, that order must be final because the merits of the case have been considered while deciding the application. Now, another Supreme Court ruling is Shiv Shakti Cooperative Housing versus Swaraj Developers and others. In this, Supreme Court laid down that if the order is interim on nature or does not finally decide the LIS, then the revision is not maintainable. Now, LIS means litigation. But yes, it do have other meanings also. So the condonation of delay does not finally decide the litigation as a whole. It does not finally decide the case. Therefore, the order should not be maintainable in revision because it may be termed as interim. But there is other meaning also, that is the dispute. Condonation of delay application is deciding a dispute. Therefore, it can be final and should be maintainable in revision. So what I have interpreted the word LIS is either the litigation or the core issues of the litigation. Now, what are core issues? It is still debatable, which I will not go in this video. In this video, I just want to make a point that law is not crystal clear. It is very ambiguous and full of loopholes. That is a big playground for advocates to play. Many a times, apart from the facts of the case or the law involved, the lawyer skills of argumenting and the lawyer skills of drafting the case influences the court's decision. The simple rule of 2 plus 2 is equal to 4 doesn't work here. 2 plus 2 is a question mark, and a good advocate proves 2 plus 2 whatever he wants to prove. And the problem before judges is that if they decide or if they laid down finally whether an order is an interim or final, or whether it is maintainable or not in revision, it will be taken as a precedent for upcoming cases, and there's a chance of misuse and misinterpretation. So they have to apply a lot of mind and allocate a lot of time in giving a full reasoning in detail that whether an order is an interim or final. And if there is a little bit of mistake, then there is a lot of scope of misinterpretations. This is the problem. For example, you are the judge and you have to decide whether the condonation of delay application is a final order or an interim order, and whether it is maintainable or not in revision. What would be your judgment and what would be the reasoning behind the same? I shall wait for your opinion in the comment section. Thank you.